big difference between alcohol DUI and drug DUI is this. Alcohol in Georgia has a legal limit that is set by law. That legal limit is 0.08 grams of blood alcohol content. And the law says if you're over that amount, then you're DUI, you're guilty. Drugs have no legal limit. So that means if the government can establish that any amount of drugs are in your system, they're permitted to make the argument that you're DUI. They don't have to prove that you're over a legal limit. All they need to argue is we found these drugs in this person's system, therefore they were DUI. Importantly, though, what the government has to show whenever you're charged with DUI drugs is they've got to show that those drugs rendered you a less safe driver, what's commonly known by most folks as being a drunk driver. They've got to show that basically you were impaired and you were incapable of driving safely by virtue of the drugs that you had in your system. So the big difference is there's no legal limit. They can pick any amount that's in your system and use it as evidence, but they have to show that you are impaired or a less safe driver by virtue of the consumption of those drugs. There's only a slight difference between how you'll be treated by the Department of Driver Services for a DUI drugs conviction as compared to a DUI alcohol conviction. If it's DUI drugs, you will have a longer period on a limited permit, aka a work permit. If it's DUI alcohol, you have a shorter period on a limited permit upon conviction. So if you're convicted of a DUI alcohol, you get a limited permit for 120 days. Then at the end of that 120 days, you get your real license back. If it's DUI drugs, you're on a limited permit for 6 months. You're on a limited permit for 180 days. At the end of the 180 days, then you get your license back. So the evidence the government's going to use in a DUI drug case is different from a DUI alcohol case because what we've already talked about, how they're usually pointing to a blood test result that has some amount of the drug in it. There are several field sobriety tests that the government claims can show DUI drug impairment. For example, the HGN test or the eye test. That is a test that can show central nervous system depressants. So it also shows alcohol. It's not very good for doing marijuana, and that's a known fact, but it can show other drugs. So they'll try to use the eye test. The other 2 standardized field sobriety tests also can be used to show drug impairment. For example, the so-called walk and turn test, where they have you walk out 9 steps, heel to toe, turn and walk 9 steps back. That's a test that tests for divided attention and your ability to follow directions, which if you're under the influence of drugs can be impaired. The same with the one-leg stand test, which is one of the standardized field sobriety tests. That's where they have you balance on one leg for some period of time and they're counting, watching to see if you sway or put your foot down. And those can be indicators to show also drug impairment. So any of those can use along with the standardized blood test if they got a blood test result showing the presence of the drug in your system. Well, the biggest strategy used in a DUI drugs case that you can't use in a lot of DUI alcohol cases is you can challenge the science that the government intends to use, specifically related to your blood test or urine test result. Let's say the government has a blood or urine test showing the presence of a certain drug in your system. There is no legal limit for having drugs in your system like there is for alcohol. The government has to prove that that amount of the drug in your system rendered you a less safe or impaired driver. And When you look around at some of the data and the science supporting the conclusions that a lab tech or I don't know what else to call them, from the Georgia Bureau of Investigations that they may testify about, the science should be good, saying, hey, if somebody's got this much, let's say, marijuana in their system, then there should be science backing that up. And if it's not there, you can file a motion that's used to be called a Harper motion, and now it's called a Daubert motion, and have the court decide whether or not the court's going to permit that GBI tech to come in and say, well, this means the person's impaired or not. So again, the biggest thing you can do is file a Daubert motion to exclude the government from being able to come in through an expert and say, hey, this amount of marijuana or whatever drug in the person's blood means they're impaired. If they can't prove through studies that that's been established, you can actually exclude that on the front end, which isn't true for alcohol.